Good afternoon, everyone. Today is September 29th. This is the seventh or eighth panel discussion from Fiduciary September 2025. And we have a very outstanding group of well-known leaders in the industry to discuss an issue that, in my view, does not get sufficient discussion. And it involves the core differences between broker dealers and investment advisors, which in many respects, not entirely, come down to the issue of conflicts of interest and how they are viewed today. So I will provide some brief introductory remarks and then hand the mic over to Chuck Fela, and who will hand it over to Dennis Moore, who will then hand it over to Jason Wenk for their opening remarks. So with that brief introduction, I will start by introducing each of these individuals by literally I'm going to read off the first sentence of their bios as they have put them on LinkedIn or on their website, to give you an idea of the differences in personalities and approaches that these guys take. And because Jason has spent his whole life being at the end of the alphabet and being last in class in terms of being called on, I'm going to start with Jason here and read his first sentence of his bio. He says, "Hi, I'm Jason Wenk, husband, father, fintech executive, writer, math geek, and investment systems developer." Excuse me, I'm going to use two sentences here. "I'm the founder and CEO of Altruist, a modern custodian for independent advisors." That is the first couple of sentences of Jason's bio. Next, I'm going to move on to Dennis Moore. Dennis Moore, MBA, CFP, is the Chief Operating Officer and Interim CEO of the Financial Planning Association, the leading membership organization and trade association for certified financial planner professionals and those who support the financial planning process. Finally, last but hardly least, I will read the first sentence of Chuck Fela. For now on, I'm just going to call him Chuck because Chuck is a good brand in the world of RIAs, and I think we ought to get that out there a little bit more for you, Chuck. As the principal of an independent financial planning firm, I pride myself on delivering integrated and unbiased advice for all of our clients' financial planning and investment management needs. There is Chuck. So they can add, of course, in their own comments, which will follow, whatever they would like to in terms of the bio. But I'm going to start off and provide a very high-level backdrop to, I think, what gets us to where we are in 2025. And this is not intended to be a comprehensive, detailed look, but just capture some high points that has greatly affected how we view, or how many people view, broker dealers and investment advisors and the importance of conflicts of interest. And I look at this as a 17-year history, which basically started during the midst of the 2008 financial crisis, when during that year it became the consensus that brokers should be held to a fiduciary standard. So I view that as the starting point. And during this 17-year history, I think of what we see from the primary regulator, the SEC, is an ongoing diminishing, decapitating, and in fact, in some ways, a trivializing of the fiduciary standard. And I know those are tough words, but I will provide just a little bit there to back them up. I want to start with the conventional and correct meaning of what is fiduciary advice, and set out in the Investment Advisors Act of 1940. This is not complicated. You don't need to be a legal beagle to be able to just look at that background. And for those who worked in the spring of 1940 and the summer of 1940 to come up with the Investment Advisors Act, it was basically straightforward. They wanted to create a new standard for investment counsel, as they were called then, and who were only paid by fees. Number one, were not did not get any opaque third-party payments. That was absolutely key to it, and that they had no other business interests. And if you look at the background of the IAA, these points are sort of summarized in a very few pages. So it doesn't take a great deal of research to sort of find them there. And that this meaning of what it meant to be a fiduciary advisor was reaffirmed by the Supreme Court in 1963 in the capital gains decision, and that's the date that we usually use that to say that investment advisors are held to the fiduciary standard. I'm sorry. Did somebody say something? Okay. I am almost done here. And then we come up with the 2008-2009 reaction to the financial crisis, where it was deemed by the policymakers and some of the regulators that broker dealers should be held to fiduciary standard. But I want to point out a very important point that was made by the SEC chair in June of 2009, and this was right after the Treasury Department came out with a white paper that officially said that broker-dealers should be fiduciaries. And then Chairman Shapiro ran up to New York and spoke before the New York Writers Conference, and she said she was very supportive of the fiduciary standard, but she made a key point here that I think has been largely overlooked or omitted going since then, and that is she believed that broker dealers and investment advisors were, quote, merging to the point of indistinguishability, unquote, from the retail investor perspective. I don't know that we can see that opinion expressed by the SEC before then, but that was a huge statement, because it basically set the course for what was to happen in the next 10 years that ended in regulation best interest. To rush ahead to 2019, and there were steps along the way where the SEC was making signs that they were changing their views on what it meant to be a fiduciary. But in 2019, they came out with regulation best interest. Many RIAs publicly said that it was deficient and publicly pointed out where it was deficient, and including one of the SEC commissioners themselves, Commissioner Robert Jackson, who was very vocal about how disappointed he was with what came out in Reg BI. And as I think of what we heard from the Consumer Federation of America and what we heard from others who were disappointed, it was a matter that the suitability standard was not being materially changed. It was being materially rebranded. And it was rebranded as a best interest standard, which up until then had been exclusively, that term had been exclusively used in legal decisions for those who met a fiduciary standard. And if there's any doubt about this disappointment, research by the state administrators, NASA, in both 2021 and 2023 have demonstrated there has been relatively small changes in how the broker dealers have done business. So with that sort of quick overview, I stand back and I look at a picture that over this period of time, the SEC has weakened sharply the meaning of fiduciary. At the same time, they have suggested that the broker dealers have become like fiduciaries, and by calling the standard a best interest standard. So the bottom line, from my perspective, is that the whole concept of fiduciary advice has been seriously weakened, and that's where we are today. So, with that sort of brief introduction, um, I will turn it over to Chuck for his opening comments.
Okay. Knut, thank you for that. And always great to be on a panel moderated by Knut and especially joined by Jason and Dennis. It's a real honor for me to be here. As Knut knows, because we speak about this quite a bit offline, I am Investment News, I think it was last year, did a 2-page article on me, pointing me out as broker dealers' public enemy number one, which is something I was proud of, and it was tongue in cheek, of course. But after that, I do like to make clear that I'm in no way anti-broker dealer. I think broker dealers play an important role in our industry in the creation and distribution of product. Super important, and that will never go away. However, the issue I have is the consumers have a hard time discerning between the salespeople, and there's nothing wrong with salespeople, and advisors, right? And I think there really needs to be a much more clear delineation between those that create products and those that advise on which products are best for consumers. I think those are two very important roles, but they should be separate. So I am very much not an enemy of the broker dealers, although I did find that article to be very funny, and I could see where they're coming from. I think it's important to have them, but I think it's even more important for us as an industry, because I'm not sure if the regulators are going to get to the promised land, which I think would be title protection. I'm sure Dennis will want to talk about that. I don't think we're going to get to that anytime soon, at least. So I think it's on us in the industry to help consumers discern between real planners and what I like to call Pinots, right? And not the tasty type from Napa County. Pinot in this context for me is a planner in name only. And I think it's important for consumers to know when they're dealing with a real advisor giving real advice versus the advice coming from the person that distributes the product, right? The last thing I'll say, and I use this analogy a lot, and I think a lot of consumers it resonates with, when you go into a car dealership, you're expecting that salesperson to tell you honest things about that car, and that's fine. But I'm not expecting that salesperson to tell me all the great things about the competing car. But as long as they tell me honest things about their car, I'm happy. And that's the broker dealer. But if I want advice on what car to buy, I'm going to go to a fee-based solution like Consumer Report. That's going to tell me the good, the bad, and the ugly of the Audi versus the BMW versus XYZ car you may be buying. And I look forward to discussing that today.
Thank you, Chuck. Next in line, Dennis.
Hi, thank you, Knut. Hi, everybody. Great to be here. Chuck said, with Chuck and Jason and Knut. Appreciate the invitation. Yeah, so FPA, the Financial Planning Association, so we pride ourselves on being business model agnostic, compensation neutral. We feel financial planning can be delivered in a variety of ways in different business models. Again, as long as financial planning is delivered under a fiduciary standard with the clients at the heart, right? So we don't look at it as the business model or the compensation defining whether you're a good planner or not, a fiduciary planner or not, right? You either are or you're not. And so that's kind of where we come in, and FPA has been a long advocate of, again, like I said, a fiduciary standard of care, everything even back to the mid-2000s, and the SEC more since then, and everything since then. And that's why our core member is the CFP professional. It has been since the start of FPA, and under the CFP professionals have to work under that fiduciary standard. So again, it's not really about business model or compensation. It's about financial planning and how you work in the life. And even as Chuck mentioned, title protection, and not to get into that too much right now, but even on that, which again, the board is still very early in those discussions and listening and everything. We came into that not with any preconceived notion of what that is, but kind of what the conversations have been around competency standards and ethical standards. So it's not about practice standards. Again, it's not about a business model. It's about ethics and competency and making sure planning is the way it should.
Okay, thank you, Dennis. Jason.
Well, like Chuck and Dennis, just want to say thanks for having me on. This is a real honor for me to join you. I've followed your work for decades, and My angle is probably slightly, different. We run an RIA only custodian, and one of the things that I observe is that there's a real difference between advice and then implementation of advice. And so, whether we're battling with the legalese around what is a fiduciary and how close is that to best interest, and I think that it is rather challenging for consumers to tell the difference for all the reasons that Dennis and Chuck pointed out. All that being said, if you're calling yourself a fiduciary, which has been a differentiator for a long time, but it is getting a bit murky, for consumers. And then you go and implement, and you all of a sudden breach your own fiduciary duty by how you implement, which in other words means, are you actually driving what's best for your clients, or are you just doing what's easy and best for your business? This could be any number of things, including like the way your custodian operates, as an example. I don't know that we're doing ourselves any favors. So if the goal is, which mine, of course, is I think the same as everyone on this, which is to really help get more people familiar with and connected to fiduciary advisors, hold people to the highest possible standard. It's very hard to do that if we're not actually doing that. And I think people are oftentimes, even those who are fiduciaries in advice are not actually fiduciaries in how they operate their business. And if that continues, this will just continue to make it harder and harder for consumers to tell the difference, because the implementation looks awfully similar, non-fiduciaries versus fiduciaries, whether they're with a broker dealer or with an RIA.
Okay. I would like to start off with a couple of questions, starting with Dennis. And Dennis, I don't want you to think that I'm picking on you, but this issue that of being compensation neutral. Explain to me and explain to a lot of investors who I suspect, and I know, and actually some research tells us they believe that compensation neutral is not the way to go. They believe, and this goes back to some research of 2018 from the SEC, that they far prefer that their advisor planner only get paid by their client, by their customer, period. So, but I want to go back and I don't want to get stuck in the legalese. So I fully appreciate that, but I want to try to have the conversation with the language that the average retail investor consumer could really understand. So I want Dennis explain to me why those who crafted the Investment Advisors Act and then the Supreme Court, who later affirmed it, are basically wrong by saying that, no, it's not a matter of being compensation neutral. It is a matter of recognizing that if you are only obtaining a transparent, understood fee that is explained in advance, that is different than a commission or incentive that is often opaque. So help me understand why we should forget what those who crafted the Advisors Act said and forget what the Supreme Court said.
Yeah, well, thanks for that. And so I'm certainly not advocating for that, not advocating for forgetting what they said or said that they were wrong, right? Again, it's more about the client, right? And so we feel, so regardless of what your business model is, you can still act and provide financial planning under a fiduciary standard, regardless of what that business model is, right? I mean, some of it on the Advisors Act and all of that require it, so that's true. The others may not require it, but that doesn't preclude you from acting as a fiduciary. And so that's our statement. So it again, doesn't matter about the business model. It matters about how you treat the client and how you approach planning. Are you doing it under a fiduciary standard? Is everything full and fairly disclosed and transparent to where the client can understand it? That's key. It all goes about the client. And so again, that's kind of back to, as I mentioned, the CFP is our core member. We have CFPs that are in a variety of business models, regardless of what that is. And they're held to a fiduciary standard under the CFP board, right? It's different from, I know it's not the SEC and everything else, but voluntarily holding themselves out as a fiduciary planner by holding that CFP designation. So that's where we're coming from. So not saying that they did it wrong or it's right or it shouldn't, or the Supreme Court did it wrong. It's more about how you as a planner, how do you work with your clients? Are you doing it fair, transparent, with the proper disclosures and in the fiduciary standard? Again, in financial planning, that's what we're focused on, that financial planning relationship.
Okay. Chuck or Jason, do you have anything to add to my question to and or to what Dennis said on that point or not?
Yeah. What I would add to that is I myself personally am a fee only advisor. I don't have a Series 7. I don't have an insurance license. And my belief is this. I do think the fee model is generally the easiest one to work as a fiduciary. And there's very few instances where I do believe commissions are required. I think the last frontier for commission business might be things like the way I refer to them as use it or lose it insurance policies, like term life insurance, disability insurance, the use it or lose it long-term care insurance, not the asset-based ones. There's no other way to deliver those to clients other than with a commission. And again, I don't have an insurance license, so I don't drop any of those tickets. But there are some younger advisors at my shop at Sovereign that do. I think it's completely fine. I think these are important products for people to have. If you have a need for term life, you should have it. If you're a young doctor right out of medical school, you better have disability insurance and the like. And I have no problem with a fee based, right? I guess would be the differentiator, a fee based advisor who's going to do everything on a fee basis other than that which can't really be easily done or in any way done in a way other than a commission basis. But I would think it's important, to Dennis's point, that it's disclosed, right? So here's my fee. This is what I'm going to charge to work with you. And if there's a divergence from that, I'm going to tell you in advance and why I'm using a commission-based product. And those really should be limited, in my opinion, to things like term disability and long-term care. That's my 2 cents on the commission topic.
Thank you, Chuck, for your 2 cents. Jason, do you have anything to add to that 2 cents?
I would say I agree on there's not a huge need for commission-based products. Yeah, very similar to kind of Chuck's observation. I do find one thing that is, I'd be curious Dennis's view on kind of the bifurcation of planning and compensation. Just because this could be slightly anecdotal. Just 20 some years of history and working with advisors, but I don't obviously have I don't have all of the data in front of me. But even the majority of fee-only financial planners who get paid for unbiased fiduciary financial planning oftentimes earn the majority of their revenue by managing assets. So it's still an asset-based fee versus a planning fee. Now, again, obviously there are planners who do both, charge a fee for the plan and a fee for sort of the implementation. But if you were to look at the lifetime value, it's a rounding error, the financial plan, relative to the AUM fees that that the majority of the industry takes. So I'm just really curious, how we think about those two things, because the actions themselves are so radically different, right? Planning versus, the ongoing sort of management of assets and charging a fee for it, even though the management of assets might be 99% of the client's total payments, for over the course of a long-term relationship. So just kind of curious how you think about bifurcating those.
Yeah, and that's an interesting question too. And I've seen it done both ways. And really, again, kind of for us and just on the compensation neutral, meaning just kind of, again, as long as it's disclosed, so even getting the AUM, and if you're providing financial planning but collecting AUM, what does that look like? You've got to disclose all that, make it transparent. But I think for us, so financial planning, right? So it's a process. The financial planning is not necessarily the plan, like something we physically hit print and hand it over and get saved and present on Zoom or whatever it may be. But it's not just that, right? It's the relationship, it's the process that's helping clients achieve their goals, which does include asset management, right? That's part of financial planning. So for us, so whether it's bifurcated and you pay just for the plan itself, separate from asset management, or it's wrapped together, subscription fees, or trails and commission, or whatever it may be, because that's the other thing for us too. We look at it and we feel like by planners being able to have that freedom to kind of have a business model that works for them and clients are targeting, opens up access to more consumers to get financial planning advice, right? Like some of them may get priced out by certain compensation models. And so for them to be able to find a model that fits for them, and everybody has access that it's a good quality fiduciary financial planning is important to us. So that's another reason why we look at that and really see, business model agnostic, whatever it may be, as long as the client's interest is what's important and is there and is provided in fiduciary standard. The comp model is one that it makes sense and it's transparent. The client understands it. That's obviously, I know that's been said a few times, but it's one thing to disclose it, but you've got to disclose it in a way to where the client understands it. So that those together is what is where we are, kind of what our basis is.
I just want to add one point to what I was generally referencing, and then we'll move on to other questions. But I'm going to the RAND research from 2018, and the question is framed this way: how important would it be to you that your financial rep receives all his/her compensation from you directly? That's the framing of the question. Not important at all, 22%. Important, extremely important, 51%. So, I don't think it's just a bunch of fee-only planners that is waving the flag out there. I think there is something to this that consumers who, right or wrong, who have thought about this or expressed an opinion about this have expressed the opinion that they have. Okay. Are there any other questions from those that are on this discussion that they would like to ask at this time? If so, let me know.
I do have a question, and this one's it's timely because it just was posed to me late last night. So by a very large, one of the largest RIA firms in the U.S. And that holds themselves out as fee only, the majority of the people, including the founders of CFP. And it was really interesting. They asked me a series of questions, and one of them was before their question, they said, "Hey, listen, we've had a number of our advisors ask about adding Altruist as a custodial option, but our current priorities are growing assets as fast as possible and maximizing profits. And what we want to know is, like, over the next 2 years, what can Altruist do for us? Can you send us referrals? Can you pay us? Can you pay us soft dollars, pay us hard dollars, and they gave real numbers that were very meaningful that they were looking for a custodian to give them. And I guess the question I have is just for all three of you, kind of how we think about these conflicts of interest, because we all just talked about there being a fiduciary standard, and whether it's planning. And if the firms and the practitioners themselves, if their priorities actually have nothing to do with their clients, kind of shame on us, if the priority is how do we get as much assets as we can and make maximum profits, which again, I'm not anti, capitalism. I guess I think firms should, of course, try to be successful, but how do we think about balancing that versus the conversation we're having today, which is this notion of transparency with clients, and truly fiduciary advice, which seems to actually be on the back burner for some of the biggest firms that have the largest reach. And really curious kind of how you all think about that.
Chuck, do you want to start?
Sure. So, and I think we've touched upon this, but I think it's worth touching on again. It's just a matter of how clear it's described to the client, right? So at our shop, we have something, and we love acronyms at our shop. So we have something we call the CASP, and the CASP stands for Client Assets Advisor Services Provided. And it states very clearly, account by account, here's the assets, here's the services we're providing, here's what we're going to charge for it. And to the extent we can get that clearly communicated to the client, to the consumer, to the prospective client, the better. But I think to Jason's point, there are some things that are just really, really hard to show clients. And I think it's on the advisor to do the right thing, but it's easy for the advisor to not do the right thing, right? So cash, right? That's, I think, kind of a natural thing to talk about if we're talking about custodians. Not all custodians are created equally as far as what they pay on cash holdings. And cash holdings could be a significant piece of drag. So how do we solve for that? Well, at many shops, including us, we have some scale. We're not huge. We're just over $1 billion. So we're not small, but we're very far from huge. But at that level, we have the ability to run overnight sweeps ourselves into higher yielding money markets. That's a little bit more tricky for, a solopreneur to do, but I think it's important to do. But how does that solve the question? Because if the consumer doesn't know to ask for that, how would they know to ask for that? And I think it goes back again to the industry taking the lead, because I'm not sure if it's going to come from the regulators, to help clients understand what their true costs are. And even in a fairly pristine fee-only basis, there are some room for some costs that may not be completely transparent, right? Cash drag is one, and I'm sure there's others, but that's the one that really comes to mind. So the more we could do as an industry to alert consumers on what they should be looking for, I think the better. And if we can get custodians to be even more clear, even at the consumer level, on what some of those charges are, whether they're direct or opportunity costs, that would be helpful too. But the other side of that, and this is kind of where I'll end this, is how much information is too much? What's material, what's not, right? So for me, a problem, and really where I put my target on PNOs, planners in name only, are really those advisors, a lot of which I hate to say are CFPs. And we all know who these people are. We all know who these firms are, where they put together these beautiful, detailed, elaborate financial plans. But as the expression goes, right, all roads lead to Rome. All these plans in these Pinot shops lead to high cost, Knut knows where I'm going with this, index universal life with ridiculously high commissions. The solve for that, in my opinion, is if you are going to be a hybrid advisor where you're doing some fee, some commission, disclose all your compensation. Don't have it disclosed on page 397 of some prospectus of some VA policy, right? Have it disclosed that you are receiving $35,000 in one-time commission for that IUL product, and give at least the consumer a fighting chance to seek out a second opinion. That's where I think the bigger problems are. Could we do better with cash management and some other ancillary things? Without question. But I think if we could solve for that, because I've seen that firsthand having done this for 30 years, that's where the damage is being done. People being sold bad products for no reason other than satiating commission targets. That's the bigger problem. So, let's tackle that, which I think is a lot easier to tackle, and then we can make, strides toward perfection. But I think making it harder for Pinots to push unsuspecting clients into high-cost, inappropriate products, that's the low-hanging fruit. And I think that's where we should focus our efforts.
I think that's a good point. I want to interject something, and then I'll hand it over to see if Dennis has anything he wants to add. One of you two mentioned whether it's going to come from the regulators or the industry. I don't think there's any doubt whatsoever that it's not going to come from the regulators. And that being said, I'll say that, I think that there are many states that, notwithstanding their limited resources, they at least understand what fiduciary means. I don't know that I would say the same about many people at the SEC today. They literally don't understand it, what it means anymore. But so I think that I think you put your finger on part of it, Chuck, in talking about that it's got to come from the industry, and then the other thing is that I think it's got to come from the industry in communications and messaging that will make that in order to get through the noise, and we all know how difficult that can be. This communications and messaging is going to make some people feel uncomfortable. And if we're not willing to make some people feel uncomfortable to get through the noise, but to still be accurate and still be straight on in terms of the essence of the message, then I don't see where it's going to do much good. But so I think that is absolutely key. And our small part of this is we have distilled what we believe the best planners, advisors do to 10 practices, and we've written it in 2.5 pages. And I know that we've got to get it down to 1 page. We've got to be able to have a 1-page document that we can give a prospective client and say, this is what you should demand of anybody you work with And I hope you work with me if that's the case, but this is what you should demand. And to your point, Chuck, it's got to be in such plain language, but still be specific enough to get the point across. And and that's what we have tried to do with our real fiduciary practices. I just want to interject that. Dennis, you want to add something?
Sure, just briefly. I don't have a ton more to add on to that, but just that part of the fiduciary standard, right? One of the duties is the duty of loyalty. Part of that duty of loyalty is to avoid conflict of interest, and when you can't, fully and fairly disclose things, right? Like, so again, kind of what Chuck was saying, what you were all just saying, like, so don't have anything more that they added to say, just all the other than to just underscore the importance of the transparency and making sure that the client understands. It's full and fair, and the client understands what's being paid, where's the money coming from, how is that happening, is where it goes.
But then I'll add, unfortunately, there are many. I think there are many broker reps who want to do the right thing. I don't think it's. I focus on the firm far more than the individual, because the firm is where the bad stuff is allowed to happen. But then I go to Ameriprise, and Jason, if you've looked at a lot of ADVs, I'm sure Ameriprise takes 16 pages to answer the question how we get compensated. And I asked myself, what is a consumer supposed to do with a 16-page description? Never mind the consumer, what is a rep supposed to do with that? And I think sort of an honest evaluation is that most reps don't know what's going on behind the curtain either. It's not their fault. That's the system they work into. But anyway, I just wanted to touch on that point. Any other questions? I don't want to direct all the questions here. So any other questions from anybody else on the call? Have we covered the whole situation? Well, let me come back to Jason.
Well, if we're at that point, I do have something to add.
Okay.
So, because I think this is worth fleshing out a little bit. And I was able to share a glass of wine with Dennis over at the Quad A conference, and we chatted about this. And what I mentioned to Dennis is what I'll mention here on this panel, and that is there's very, very little daylight between the way I look at things and the way, Knut, you do in your institute. But something I would like to have you guys reconsider, and that's the following. And you know where I'm going with this.
Yeah.
I think the idea of your fiduciary pledge is the way to go. I think that's the right way to go. But it's turned into, in my opinion, a little too much preaching to the choir and not enough preaching to the unconverted that are outside the doors. That's number one. Number two, I do believe there does need to be some flexibility, because I would like to sign that pledge, but I can't. And I can't sign that pledge. I'm fee only. I don't have any insurance or commissions license, don't do any commission business. I cannot sign that pledge because within my shop, I have 2 advisors, younger advisors, that as part of their planning and implementation, they sell term insurance. And I think that's wrong to exclude them from being able to sign such a pledge. And I think what I described before would solve for this. In other words, we are fee-based and we're pretty much fee only. And that's not really good language, I guess. We wouldn't use pretty much in an official document. I'm sure we could find something better than that. But something to the effect of, if we diverge from being fee only, there'll be a reason for it. I will give you, not, paragraph or two, I'll give you a sentence or two on why we did deviate from that. And I will tell you what my compensation was. And it would go something like this. We are fee only, but you need term insurance. Someone is going to receive that commission. There's no way around it, right? David Lau over at DPL hasn't cracked that code yet. He's done a great job with annuities and with some insurance, but not term and disability and use it or lose it long-term care. Let these advisors recommend those important products. And if they're willing to do the work, I'm very fine farming that out. I'll identify the need in my planning process and I'll farm it out because I don't really need to write a term policy. But these younger planners do. And these younger planners are serving a population that needs term insurance and disability insurance. Let them disclose it and let them too sign that fiduciary pledge. And then let's really get to work on making sure people outside of these panel discussions know about this pledge, right? And what I thought would make for a wonderful, and I'll give this a plug, Knut knows where I'm going on this too, what I think would make for a wonderful, incredibly important social media campaign would be advisors like me, time tens of thousands, holding up the pledge saying, I signed the pledge, did you? I signed the pledge, did you? And that, I think, will trickle through the internet and have consumers know to ask their advisor, did you sign the pledge? I think that would be an interesting thing to look at. And if we want to really make an impact, other than talking amongst ourselves on how important it is to be a fiduciary, we got to bring that message outside the doors of the chapel and let the people outside hear that message too. But you got to let the good advisors that do sometimes sell a very reasonable commission product, of which I'm not one, but there are a lot of good advisors that will, let them in on that party.
Yeah.
And let us all let the consuming public know that they should ask to work only with an advisor that has signed that pledge.
Gotcha. Two quick points, and then I'll let anybody else reply. First of all, our rough calculation is that of the 300,000, the Cerulli 300,000, we estimate that 7% could meet our practices, and yes, and that does include fee only. So but our view has been that that our focus should be the 7% as opposed to the 93%, because the 93% are a tougher row to hoe, so to speak. So I think that is one point. But the other point that you make, and we get to this in all of us in various different ways, is the way you framed it before. How much disclosure, it really does the good that we want it to do, as opposed to how much of it is overload and it doesn't do what we want it to do. And as you know, Chuck, a big piece of this is that it is far easier to determine whether somebody is fee only vis-a-vis their ADV than it is to go through the process of determining whether the way that you describe a practice, I view that practice is culturally fiduciary, with the small exceptions that you define. And in fact, when we started out 10 years ago, that's where we were. But interestingly, partly that was based on, in large part, Ron Rhodes, to me, has written the book on what do you need to do to overcome a conflict of interest, as an advisor planner. And I don't see anybody following him other than ourselves, in terms of, we all agree that it's disclosure that is understood, but how do you get to the point of disclosure that is understood?
Keep it to one page.
I don't see anybody else doing it. Whether it's the SEC, whether it's CFP board, it's as though Ron Rhodes does not exist on this planet, because he's written more about this than anybody. So that comes into it. But your larger point is well taken, and is again what I think of as culturally fiduciary. And if it's 2 or 3% of the revenue, or whatever it is, or 5%, then that comes from a commission. Then I don't, I agree with you that why are we so focused on that? I think that's a good question. But we are on looking at our practices on an ongoing basis, but so far we haven't been able to take the leap. But to take the same question of conflicts of interest, going back to Jason, who posed the question, I mean, I'd be, you posed the question, but I'd be interested sort of in your view, and maybe you partially got there in the way you made the question, is the view from the larger firms of what this thing called conflicts of interest means. My perception is that, if you want to make a generalization that's fair, that the smaller firms generally are a lot more sensitive to it than the larger firms. But that may be unfair as a generalization. So I'm curious, Jason, whether you have a view on, from the larger firm point of view, uh, what your sense of what conflict of interest means to these firms.
Yeah, I mean, I guess I have this is hard because I would say that to use like the data or sort of the example Chuck gave a moment ago, the total premium annually for index universal life insurance is $17 billion, right? So assuming every single dollar that went into those policies was a complete loss, it wasn't appropriate for anybody, every single dollar got wiped out. Then you compare that to the amount of assets that RIA's custody, which is north of $8 trillion. And if there was even 0.2% of friction, you've got essentially the same dollar amount, right? 16 billion dollars, right? So I think actually what's interesting to me about conflicts of interest is I feel like um, you know uh, I feel like many people only want to do the right thing or do the hard thing when it's convenient for them. And so it's a lot easier to say, well, we shouldn't make commissions on products or something like that. But it's a lot harder to say, hey, I'm going to hold every vendor I have to the same standards of care that I profess to my clients. And I think the same is true again across many of the different bodies in our industry. So there's a lot of different organizations that kind of have these. And please don't take any offenses, but these sort of self-righteous views, almost like almost borderline narcissistic, where it's like, well, I'm always right, of course, like my way is definitely the right way to do things, type of thing. The reality is far more nuanced. Like it's almost impossible, actually, I think, to land to a place where we're in absolute terms doing the right thing. Because there's always going to be some amount of friction. And if we went to a place of saying, well, what would be the most impactful, like what would actually drive like the largest amount of impact? I think there's probably two ways. There's probably lots of ways, but two ways I would measure that impacted. One is very purely just client outcomes, like what would, broadly speaking, on the aggregate, drive the best possible outcomes for people, for the end consumers of advisors or planners or reps, and how could, like, what has to be done to increase that aggregate outcome. The second might be what could be done to decrease the number of like full financial blowups, right? So in other words, like there are cases where, because of undisclosed conflicts and sort of the P&Os that Chuck referred to, they call themselves a planner, but the reality is they're out there just like incinerating, people's money, and kind of doing it with no recourse. And so if I was looking at it from those two angles, I struggle a lot, with like where do you focus your time and attention, because they're actually quite different. Like the solve isn't the same, for either. In other words, like if we wanted to create the biggest impact in aggregate, we would actually pay a lot more attention to things no one wants to pay attention to, which is the implementation of the plan. Built the plan, we're monitoring the plan, the planning is an ongoing evergreen thing that happens for the duration of the client, but the implementation, actually, these very small percentages of sort of friction actually compound to the largest total amount of delta that it costs consumers. But it's very inconvenient for advisors to actually address that. It's just they don't want to do that work, and it's almost easier to like point out that there's a relatively small percentage. I think to your point, Knut, like I think most advisors are genuinely good people that want to help their clients. Could be the platform they're part of, the firm they're affiliated with, for any number of reasons. It's a smaller percentage of the planners that are doing the financial destructive stuff like that are, it's not like 90% of the advisors out there blowing up clients' financial lives. It's probably a few percent, but they're causing the disproportionately largest amount of damage. So it's a long, rambly answer. Suffice to say that, like, I wish I had a plan or solution, but I do think like it's one that no one really talks about the uncomfortable stuff. They want to talk about the stuff that's like easier maybe to implement.
Yeah.
I think Robert had his hand up too.
Yeah. Bob, did you want to say something?
Yeah, I do. I want to come back to Chuck's point of his two young planners. I guess the question is, if you allow for term insurance, probably a very inexpensive product, I use a lot of it. What's next? What's going to come after a small amount of term insurance? I mean, you could have a $5 million term policy. That's not normal. I mean, I concede that.
Sure.
But what's next? If the Institute concedes the fact that yes, we can do the selling of some products but not others, where does it lead? Where does it go from there?
Yeah. Well, I think the solve for that, the way I proposed to Canute at least, was the following: that if there is a need for a commissionable product, one or two sentences, why, and then precisely how much compensation are you receiving? And
So,
then
in
you
other
can do
words,
whatever you want. So
does
if
that
you
mean
think yeah, if you think, for example, an IUL, with a $35,000 commission makes sense, well, okay, give me two sentences on why we're doing this, and let me know you're receiving $35,000 at a minimum. And again, my whole idea on this is let's not let the perfect be the enemy of the good. When someone sees, even a fairly unsophisticated consumer investor, sees that someone's going to make $35,000 in one day, one time on this product, at a minimum, it's going to give them some pause with the hopes, my hope, that they would get a second opinion from someone that might have a solution for that same set of circumstances that doesn't require a $35,000 commission. The best way is to absolutely regulate ethics, which of course is impossible, right?
great?
So at least we could say very quantifiably, if you're going to move away from a fee only for this instance or that instance, why? Give me a sentence or two. Well, for term insurance, there's no alternative. If you want term, there ain't no term, at least that I know of, that doesn't have a commission. And here's what I'm going to receive. That's what it's really intended for. But to protect the people from the P&Os, right, I would argue is really one of the biggest abuses I've seen of consumers. I've seen it firsthand. I've seen people come into my office with a copious amount of very poor, high commission, those good old fashioned 10, 12% commission annuities that make just no sense. That I think if those people saw how much that advisor was receiving in one time upfront commission, it would have had at least some of them seek a second opinion.
Okay,
Is that
Chuck,
perfect? No, but I think it's better than what we have.
Chuck, this is where I'm going to jump in and sort of, in a sense, reiterate what I said about the issue of enforcement. Now, enforcement of if there is the perception that there is no enforcement, then it doesn't matter at all. And this situation, which is probably a simpler situation, I think can quickly get into something that becomes a lot more complicated and a lot messier. But so the as I did say before, my gut tells me that I don't know how you enforce it, and the answer there may in fact be with AI in a few years in front of us, where we don't have to rely on humans anymore to do the enforcement, quote unquote. But I mean, when I stand back and look today, and I look at CFP board, their whole move towards fiduciary has been, professionalism by proclamation too much of the time, and there's an acknowledgement that they can't enforce it as they should be able to because they're not a regulator and all that. But that's the in some respects, I think the poster child of what happens when pinky square, I'm going to be a fiduciary for you, absent any real enforcement. But I also want to get back to Jason. You made a comment about those who hold themselves out as being at a higher standard, and I'm reminded of, and Bob knows this very well from the early days, particularly that's how NAPFA was greeted. How can you be holier than thou? And so not to just to sort of get into maybe one more nuances, is it easier to think of something as a better solution as opposed to the best solution in terms of dealing with this issue of, I guess in this case it is fee only, and and I know that everybody is not legalistic in the sense that I am, but I go back and look at the original law, and I go back at the Supreme Court, and again, this was not a bunch of wild radicals in the early 80s pulling this out of nowhere. It was pulled out of the law. and I scratched my head. I remember very vividly, and then I'll stop. A certain commissioner at the SEC actually made a point of saying that so and so has to adjust their halo, and I thought to myself, "Oh my goodness, this is where we've come." And this was about 10 or 12 years ago. It wasn't recently, but that was this commissioner's way of making fun of fee-only planners. I've got to adjust my halo. And anyway, so I just wanted to put that out there, Jason, because I think you raise a good point in terms of how do we deal with that scenario. So any additional thoughts on anything that we've covered? No?
I'm afraid if we get started on another topic, we'll blow right past our
Yeah.
our
There's
2 minute end time.
That is a good point. So anyway, let me thank Chuck and Dennis and Jason, and let me give a special thanks to Chuck because he was the one that I first reached out to, and then he reached out to both you, Jason and Dennis. And I think the differing views made for an interesting conversation. So on that mark, since we don't want to blow past the top of the hour, I appreciate your time. And as I say, we'll have the recording up in the next day or two, and I will let you guys know when we do so. So on that mark, thank you, and enjoy the rest of your day and your week.
Okay. Thank you all.
Thank
Enjoy
you.
the conversation.
Guys.
Bye-bye.
Bye, guys.